When a marriage or a de facto relationship breaks down, it is important to resolve a property settlement as soon as possible. Time limits may apply. A property settlement is the reaching of resolution on the division of assets you and your spouse either own individually or jointly, including assets that are owned by a trust or company that one or both of you control. It is important to know that each case is different and it does not involve a mathematical exercise. No formula is applied to obtain a predictable result. It is a discretionary exercise. Given this inherent discretion and the impossibility of predicting a certain outcome, our job is to provide your worst case and best case and achieve the most successful outcome within those parameters. In looking at a property settlement, firstly, there is no presumption or starting point that the assets are to be divided equally. Secondly, non-financial contributions to the home and family are recognised in a substantial way. Thirdly, generally, no asset is quarantined or excluded from consideration and can include assets you owned at the time you began living together, while living together, and after separation. And fourthly, the net value, not the gross value of assets, is applied. Ordinarily, the value assigned to an asset is its current value at the time of agreement, a court application, or final hearing. At the end of the day, you have to agree, or if you can't agree, a court will have to decide essentially two things. Firstly, the division of the assets, liabilities, and superannuation interests of each and both of you, determined and expressed as a percentage. And secondly, what assets, liabilities, and superannuation interests that each of you are to receive or retain to constitute your percentage entitlement. While it is a discretionary exercise in reaching a property settlement, the law requires us to work through a step process in determining the percentage division. The first step is to identify and value the current assets, liabilities, and superannuation interests. If there is an asset that is not to be sold and the value is uncertain or not known, one agreed valuer is appointed to determine its value. Second step is to identify and evaluate your respective contributions during the time you live together and after separation to the date of agreement or a court trial. The term contributions will include the financial and non-financial contributions each of you made during your relationship or marriage and after separation to the buying and maintaining of assets and businesses and caring for children and the family. The third step is to identify and assess the present and future needs of each of you. Factors often cause an adjustment are the fact that one party may have a greater earning capacity than the other, that one of the parties will continue to be predominantly responsible for the care of a child or children, or that one of the parties has a significant health issue compared to the other. Once the above steps are all considered and weighed, a determination of the division of the assets, liabilities, and superannuation interests between you both is then reached, either by agreement or by the court. If you have a property settlement matter you wish to discuss confidentially, please do not hesitate in contacting me or one of my team.